and policies, board performance evaluation, remuneration benchmarking for non-executive directors, amongst other governance services. We also provide company secretarial support, training for directors and senior management, leadership trainings, business advisory and regulatory compliance, executive talent recruitment and director selection, surveys and research. For more information, please visit our website, www.dcsl.com.ng, and also follow us on social media at DCSL Nigeria and also at DCSL Corporate Services Limited. Now to the business of the day. President Muhammad Buhari on August 7th, 2020 signed the Company and Allied Matters Act, which repealed and replaced the 1990 Act. The new CAMA can be described as Nigeria's most significant business legislation in the last decade, as it introduces new provisions that promote the ease of doing business, reduces regulatory hurdles, fosters investment, and most notably, updates the law in line with current global realities. So the aim of this webinar is to discuss the major changes introduced by the Act and how these changes impact small, private, and public companies. It will also provide attendees with insights into the ripple effects on the operation of business, the positives, the negatives, and the challenges posed by the changes. To discuss, to dissect this subject, we have assembled a team of lawyers and subject matter specialists who are professionals in their respective fields and leaders in their own right. To lead the discourse this evening, we have Ms. Ayotola Jagun, the Chief Compliance Officer and Company Secretary at Oando PLC, who will be moderating the discussions today, and three distinguished experts, Mrs. Tosin Najose, Lead Advisor, Gill HQ Advisors, Mr. Tulilope Chonaike, Assistant Director, Registry Department, Corporate Affairs Commission, and Mr. Shofola Ocho, the Company Secretary, Legal Advisor at Development Bank of Nigeria. As noted earlier, today's proceeding will be moderated by Ms. Ayotola Jagun, the Chief Compliance Officer and Company Secretary of Oando PLC. Ayotola has a Master's in Corporate Governance and Business Ethics and is a Fellow of Governance Institute UK. She's an experienced lawyer with 8 years of experience at the bar and has spent most of her legal career in corporate practice, working across various jurisdictions, including the UK, Bermuda, and Nigeria. She has a passion for anti-corruption, compliance, and corporate governance, and speaks regularly at anti-corruption and corporate governance, local international conferences, and lectures. She is a council member of the Nigerian Bar Association's Women's Forum and currently heads the MBAWF External Relations Committee. She also heads the Equality in Law Focal Group of the Nigerian Economic Summit Group, Community of Practice on Gender. So before I hand over proceedings to our moderator to begin this session, I would like to remark that we intend for this webinar to be as interactive as possible, as the subject has direct or indirect impact on our professions, our industries, and our business. We therefore urge participants to leave comments and contributions in the chat box and questions in the Q&A box and stay muted to avoid background noise. So please note that this webinar is streamed live on our YouTube channel, DCSL Nigeria, and we urge you to inform your colleagues, contacts to be part of the webinar. I will leave the stage temporarily as I hand over this discourse to Ms. Ayotola Jagun. Ms. Jagun, please.
Thank you very much. Thank you, first of all, to DCSL for the invitation to moderate this very important panel session on the discourse on the Companies and Allied Matters Act 2020, and particularly looking at its implications for businesses. Over the last week or two, there have been several webinars, and I don't actually think you can exhaust discussing the CAMA 2020 because it's actually quite a detailed act with various sections, and as we take time to grapple with the provisions of the act and what it means first of all, and then what it means for business, I really think that we can only it's only a good thing that we continue to have a meeting of minds and discuss fully various aspects of the Act. Obviously, there have been mixed receptions. We all know by reading the newspapers that the section on incorporated trustees has had quite a bit of pushback on the sections relating to that, particularly relating to the removal of trustees. There are concerns regarding when does the Act actually come into force, what version of the Act is in circulation, and then different areas regarding the corporate governance aspects of the Act, merger and acquisitions, the whole area of netting off, independent directors, quite a lot to grapple with. And so I'm very much looking forward to this webinar and to speaking to, we have, some three erudite and knowledgeable speakers, panelists, who will give their views on various aspects of the Act. So I'm going to start off by introducing the panelists. And as we've heard, we really do want this session to be as interactive as possible. And so we are hoping that people will send through their comments, their questions, as Chinedu has said earlier on. I'll start off by introducing Mr. Tolulope Shonaike. He's a graduate of law from the University of Benin, and he is presently an assistant director in the registry department at the head office of the Corporate Affairs Commission in Abuja. He served as a member of the Senate Technical Advisory Committee on the review of the Companies and Allied Matters Act, and also the Investment and Securities Act, ISA. So as far as the CAMA is concerned, he is an authority. He has served in several capacities in and on behalf of the Commission in the course of his employment. And they include Secretary of the Harmonization, Legal and Enforcement Subcommittee of the Financial Services Regulation Coordinating Committee, obviously Secretary of the CAMA Review Committee, member of the Nigerian Defense Team to the OECD Global Forum on Transparency and Exchange of Information on Tax Purposes in Paris, France, and that he did in 2013 and 2016. Head of office in Abeokuta, head of office Lagos in Alausa, head of office in Lagos Island, and a member of the Senate Technical Advisory Committee, as I mentioned earlier. Mr. Tolulope Shonaike, you're welcome to the panel. We also have Mrs. Tosin Ajose as a speaker. She is a business lawyer with over a decade experience. She's well known for her commercial savvy, excellent analytical skills, her vast transactional experience, and her relentless desire to add value to her clients through coming up with innovative solutions and forward-thinking ideas and attention to detail. She is an astute public speaker. She is an IFLR ranked lawyer. She has over 100 transactions to her credit across corporate, commercial, merger and acquisitions, private equity, capital markets, real estate, finance, and infrastructure practice areas. She's a partner and lead advisor at Deal HQ Partners, which is a transaction advisory firm in Lagos, Nigeria. And she was recognized at the Nigerian Legal Awards as one of 40 under 40 lawyers in Nigeria in 2018 and 2019, and also named the Africa Woman in Real Estate by API South Africa. She's done extensive policy work as well in the financial services space. First as legal enabler under the Central Bank of Nigeria's FSS 2020 initiative, as a member, professional member of the National Housing Finance Program, set up by the Ministry of Finance. She is currently a volunteer with the Presidential Delivery Unit, Office of the President, Federal Republic of Nigeria, and a member of the Mining Thematic Group of the National Economic Summit Group. So Tosin is a thought leader obviously in the real estate, construction, and capital market space. And Tosin will be talking to us today about the M&A and transactional aspects of CAMA 2020. She's a regular resource person and trainer at the Pan-African University, and also a member of the adjunct faculty of the Center for Housing Studies, University of Lagos. So welcome, Tosin. We very much look forward to hearing from you. Thank you. We also have, last but certainly not least, Mr. Shofola Osho, who is a legal practitioner with experience in governance, risk, and compliance support for major corporates. He is the company secretary legal advisor at the Development Bank of Nigeria. He has worked with various organizations in various capacities. At Siemens, he provided local content support for the implementation of the Siemens anti-bribery controls and was a participant at the Talent at Compliance program held at the Siemens Leadership Center in Feldafing in Germany. At Access Bank, Shofola was a member of the legal stream for Project Star, which was a 50 billion naira acquisition of Intercontinental Bank by Access Bank, and it remains the most audacious corporate acquisition by any listed Nigerian company. He was a team member for the inaugural subsidiaries board evaluation project at Access Bank, and personally handled the corporate governance evaluations of Access Bank Ghana, Access Bank Zambia, and Access Bank in Rwanda. At First Bank, he was assistant company secretary and provided secretarial support to companies within the First Bank group, and a member of the inaugural stream of the Senior Management Development Program at First Bank. Also, he was the only lawyer who qualified for that stream, so that speaks a lot to his commercial savviness as well. He's a chartered secretary, ACIS, an associate of the Institute of Chartered Secretaries of Nigeria, a certified anti-money laundering specialist, a member for the site of the Society for Corporate Governance Nigeria, and he also holds a number of governance, risk, and compliance related certifications. So that's an introduction to the panel. You are welcome, Mr. Shofola Osho. The next thing I think we will do is there's a poll that we would love for participants to contribute to. And I believe that we have the poll set up, and I will really encourage all participants on the call to fill in, the poll. Questions have come up on the screen. So it says, have you taken time out to read through the new provisions of CAMA? And can you, yes, I have read the act, or partially, or if you can click on that, which applies. Second question, which of these reforms under CAMA 2020 would you consider to be the most favorable to your organization? Third question under CAMA 2020, the appointment of a company secretary and external auditor is optional for small companies. Do you consider this to be a good development, bad development, or are you indifferent? And which of the following best describes your opinion of the new CAMA? Okay. Nikki, I'm not sure when you want us to look at the results of the poll and how quickly we can have that information. Or do we just go straight into the panel discussions? I think it might be interesting to just see the results of the poll. We are still doing good for time. Okay, excellent. So for the first question, 44% have partially read the Act, and another 36% have read a summary or newsletter. So roughly about 80% therefore have some kind of knowledge about the Act. Which of these reforms under CAMA would you consider to be the most favorable? We have 36% voting for virtual board and annual general meetings for private companies, followed closely by electronic signatures at 28%. Single member companies is 17%, I think. And then under CAMA 2020, the appointment of a company secretary is optional for small companies. 48% view this as a positive development, while 35% view it as a negative development. 17% are indifferent. And in terms of which of the following best describes your opinion of the new CAMA, 38% believe it fosters investment and promotes ease of doing business. 22% say all of the above. So that's about 60% believe that, it's definitely a positive. 10% believe it mirrors good corporate governance and best practices. 23% are not sure. There's still, the jury is still out for 23%. So hopefully by the time we are done with the webinar today, some of that 23% will have some clarity regarding the Act and how they feel about it. So we'll just start off, and to start off, I would like to ask a question of Mr. Tolulope Shonaike from the Corporate Affairs Commission. Mr. Shonaike, what do you believe is the philosophy behind the new Companies and Allied Matters Act 2020, and what is the philosophy behind it?
Thank you very much. Thank you very much, Ms. Jago. And again, I thank you for the opportunity to address these issues with all our participants. Indeed, the CAC appreciates the honor. Like the RG would love to be in here in person, but again, like you are aware, it's addressing presently another webinar on CAMA 2020. And a lot of that is going to go on as part of the stakeholder engagement that we are committed to. Now, the CAMA 2020, its principal objectives, the philosophy behind it, is to make doing business and registering business easier, cheaper, and faster. So we address cost, we address turnaround time, we address efficiency, and also transparency. Now you find that a lot of focus on the new things in CAMA would be around small companies and private companies. Again, because we believe that these are drivers of the economy. As they engage in the workforce, they engage over 80%. And it's also on record that they contribute about 50% of the GDP. So the focus, the philosophy is to make business simpler in administration and running their proceedings, to also make it faster in accessing CAC, services, and to also promote transparency, stakeholder engagement in company proceedings. Thank you.
Thank you very much, Mr. Shonaike. But as relates to companies that are not small companies or SMEs, MSMEs, what is the philosophy? What are you trying to achieve with some of the amendments to the 2004 Act that we can see in CAMA 2020?
Okay, thank you. For instance, for the bigger companies, we also think that there needs to be more transparency, more stakeholder engagement. For instance, talking about the e-meetings, we know that, yes, it does not apply yet to public companies, but it applies to all private companies. Now, we have a number of private companies who are not small companies. For instance, EcoBank, First Bank. These are private companies, but we know that they are bigger than most public companies. Now, we also want to promote ease of engagement, ease of participation by all shareholders. And that is why we said, and the cost of also getting them to participate, cost of running their businesses. And that is what e-meetings will promote. There are other benefits to even public companies. For instance, the issue of independent directors, the issue of limiting directorship in public companies to not more than 5, so that to reduce the issue of conflict of interest, and to also promote value addition to their presence on the board of the companies.
Okay, thank you, Mr. Shonaiki. Now, I'm going to go on to Mr. Osho. Mr. Shonaiki had said that the appointment of independent directors is a benefit to a public company. Would you agree with that statement, or do you think that perhaps maybe some of the provisions that are seen as of benefit to public companies actually create burdens, additional burdens to public companies? I just would like to hear your views on that.
Okay, thank you, Ms. Jago. Before I go on to answer the question, let me just lay the foundation for the issue of independent directors and where it came out from. So the independent director is an Anglo-Saxon market-based device that came out of dispersed shareholdings, dispersed shareholding structure. It originated from the UK, United Kingdom, and it was transferred all over the world where you typically have dispersed shareholding structures. So it went all the way to the US, parts of Asia, and then on to the rest of the world. It's typical of dispersed shareholding structures. So if you go into continental Europe, areas like Germany, Italy, they've evolved their own devices. So they have the two-tier board structure where you have the management board, the board of executives, and then you have the board layer at the top, which is the governing board, essentially. So the independent directors, what do they really do? Why did we come up with independent directors? 3 broad functions: to check management excesses, because they're not supposed to be connected with management of the company in any way. They are not shackled to management of the company. They're supposed to look after minority interests in the company, because you have minority shareholders who might not have board appointment powers. They can't appoint directors. And finally, I've just grouped them broadly. Finally, they're supposed to look out for stakeholder interests, because the incorporated entity got its nature out of the goodwill of the society. The corporate personality principle was a gift from society to businessmen. So there is this belief that the company must pay the society back by balancing its interest for profit with social investment and taking care of society. So basically, these are the things that independent directors are supposed to do. So yes, it's a market device, which is very, very good. And it is interesting to note that we've had the issue of independent directors in all codes, Nigerian codes, even before the CAMA adopted it. But you see, I have a problem with when you legislate a market device. You should allow the market itself decide and develop. Let the markets grow to a level where they take on devices and they use them well. You can leave that to the markets and sectoral regulators to come up with market protections, but you shouldn't really legislate it. And I'm saying this because if you look at the new CAMA, Section 275, it now compels public companies to have a minimum of 3 independent directors. CAMA doesn't take into the cognizance the size of these public companies.
Correct.
Just legislates. So you've now legislated a market device that doesn't look at the structure or your operations. You must have at least 3 independent directors. One other thing the CAMA has done, which is a bombshell, and I'm sure it's going to shock even members of the panelists and participants, is that by Section 275, sub 3, CAMA has defined for Nigeria who an independent director is.
Yes.
Essentially. So what you have in the SEC code, what you have in the CBN code for deposit money banks, discount houses, development finance institutions, what you have in the NCC code, what you have in the national code,
yes,
must all, with respect to the definition of independent directors, must all fall to the sea of oblivion, because now Kama has defined for Nigeria who the independent director is. I know as we go on in this webinar, we're going to talk about how effective that will be. But let me just leave it there for now and then allow other panelists to.
Yeah. And Mrs. Mrs. I want to ask you, because the definition of independent director under CAMA appears to differ, as stated by Mr. Osho and has highlighted by Mr. Osho, from that of existing codes of corporate governance. And in fact, the definition seems to apply more to non-executive directors as opposed to independent non-executive directors, in that, you know, the threshold is 30%. And it says also that a significant shareholder has to have a say in the appointment of that independent director, which under other codes would, if a significant shareholder or substantial shareholder is appointing a director, that somehow
disqualifies you from being independent. Yeah.
How do you do that?
Okay, I think for starters, I think that the principle around having independence is good. We are trying to reinforce, you know, good governance principles in doing business. So I think it's good, but I think that over legislation is always a negative. I agree that legislating the number to 3 is not very good for the market, and I'd say the reason why. I mean, the ideal ratio of independent to other executive and non-executive directors typically is perhaps about maybe 1 to 3 or 1 to 4 in terms of what is ideal in board constitution. So mandating that you have 3 independents who don't really have a stake in the business means that you would be looking at having maybe about twice that number of non-executive directors. There's a role that each, you know, dimension, each community plays on the board. And like Mr. Shofola explained, the independents ensure that there is a balance of interest across all the stakeholders. That's why they are there. But it does not take away the fact that the people who have put their sweat and blood in a business should not have, you know, sufficient say on the board. And so by the time you legislate and say 3, I mean, that already makes, you know, it defeats the purpose to an extent. And one of the things that I know certainly is that governance is actually expensive. And we must realize that, you know, governance must always be relative to the size and the purpose of the business. You cannot legislate governance, you know, with a long stick and just say, you know, this is what, you know, would happen. It has to be relative to size and the purpose of the business. And then finally, the definition of independent directors based on the Companies and Allied Matters Act fails in terms of best practice. The expectation is that you are independent because you did not have any link. First, you don't have a stake in the business. You don't have any direct link to any shareholder such that will make you would raise an issue of conflict, or you know, wanting to protect or preserve the interest of one particular stakeholder group as against the other. So, I mean, I want to believe that it's an error or an omission. I don't know how, you know, we got there, but knocking this is not to say that there are not many other positives in the act. You know, this is just one, you know, imperfection that I think, you know, as we go along and, you know, we all work our way to this new regime, I'm sure, you know, adjustments that are necessary will be made as we go along.
Correct. Thank you very much. This question is for Mr. Shonaike again. We've seen that, you know, there has to be some form of harmonization, maybe when the regulations are coming out, or subsequent amendments to harmonize with existing codes and with best practice in terms of corporate governance. How does the CAC intend to work with other regulators to ensure effective implementation of the new provisions? And what do you see, in your view, what would you see to be the key challenges with implementing the new act?
Thank you very much. Indeed, like Tosin said, this is one area of oversight in putting this law together. We all agree that there can't be a perfect, there's never a perfect legislation, and this is a very huge one. In fact, the largest legislation in Nigeria. It's one area that we cannot address by regulation because this is a substantive provision of the law. So it's something that we need to observe and quickly think about amending. Because indeed, when we took another look, when we took a second look, when we saw it eventually, I mean, you must also understand that this process took it took us over 5-6 years to get to this point. Now, the final document involved a wider assembly of stakeholders who came with their ideas and all of that. And at the end of the day, this was what came out. Now, by the time we realized it, we felt we should let the process continue and let it become law and then pursue an amendment later. Because if we had insisted on correcting any other thing, we would have had to start all over. And knowing our experience in getting this to this point, that just could not have afforded another 2-3 years. Mm-hmm. So having said that, what is important is that we don't have to wait another 30 years before we do a review of this law. In fact, for me, I would say every 2-3 years we put things together and pursue amendments. Even if it's faster than that, fine. The problem with implementing this, because like Tosin said, we did not take into consideration, even Mr. Asha said the same thing, that operations of the public companies. I mean, for an environment that does not prescribe a minimum of directors, numbers of directors of public companies, it will be difficult to now put a figure. And I think that is why in most jurisdictions, you say at least one. Because there is nothing disqualifying a public company from having only 3 directors or 4. So if you say 3 independent directors, does that mean all directors must be independent? Again, that is going to be a problem implementing that aspect of the law. But we are engaging. Indeed, we are engaging other stakeholders. And in a few weeks from now, we hope to generate some clarifications, some write-offs, some circulars, and to clarify many aspects of the law, including this one. Indeed, this is a challenge. I do not see how we can implement this without a problem. If we must implement it across board public companies.
Thank you. So I'm going to ask you the next question because it kind of like flows. In compliance with modern technological developments, as well as the provisions of the Evidence Act of 2011, CAMA now provides that an electronic signature is deemed to satisfy the requirements for signing in Section 101. And the Register of Transfers, it also acknowledges electronic registers. The new Act also contains provisions to promote the digitalization of authentication, issuance, and filing of documents. For instance, Section 860, which permits documents to be filed electronically with the CAC, and also Section 175.1, which permits shares to be electronically transferred. My question to you is, from the perspective of the regulator, 1, does the CAC have the requisite technical infrastructure, sufficiently trained personnel to effect the digital transformation anticipated under these sections? And what are the potential pitfalls and challenges with the use of electronic signatures? And then I'm going to tie something else in. And this relates to, this is a great move on the one hand, but then for public companies, asking that public companies should publish in 2 national newspapers the list of unclaimed dividends. For a company like mine, which has over 260,000 shareholders, and it could go into, more pages than the newspaper itself, it just seems to be a conflict. On the one hand, you're recognizing electronic, and you're advocating for electronic signatures and electronic registers. On the other hand, we're appears to be drawn back to the dark ages of having to publish names in national newspapers. And how do you deal with the cybersecurity risks and the data protection issues, and also the fact that we live in a society where not just internet fraud, but fraud is rife? How does the CAC reconcile that?
Thank you. The first, well, that's a long one. I'm trying to also articulate them, to remember them one by one. So please, if I miss out on any of them, just prompt me. Okay. Now, I think the first one is the issue of electronic signatures and e-transactions with the Commission. At the moment, as some of these things are already ongoing. At the moment, when we dispatch certificates of registration to customers, we do it now by courier, and the end view is to the point where we don't even have to send things to you manually anyway, whether by courier or post, where you can just have your electronic certificate, and that will suffice. No, but we're not there yet. We're working on that, and we hope to be there very soon. Now, at the moment, we don't insist that you give us your physical copies, the copies you uploaded, right? We don't insist. So you can't say that end to end now, it's for what you have, your documentation is electronic, right? It's electronic. And we're hoping that in a few weeks to be able to deploy some post-incorporation processes online, and we'll be having challenges in that area, but we're working seriously to make sure that we overcome those challenges. Now, for some of the pitfalls, the major one I would think is the issue around electronic signature is more of forensic. Forensics. I'm not a forensic expert, but I know that for forensic experts, wet signatures are easier to analyze than the electronic signatures. And I think that had always also been a pullback for us, because we should have gotten to this point earlier than now, but that had always been a concern. But thank God we're here now. And we'll find the forensics people have to just find a way around that, because it's a global practice. So we have to embrace it. We're not an island. We have to embrace it. Now, we're also not unaware of the challenges of cybersecurity. Again, regulations will follow shortly. And I think we address these issues by regulation. The same thing with the issue of publication of dividends in the newspapers. I understand the concern, but the idea is to make it more accessible, create a better opportunity, a better chance for people with unclaimed dividends to know that they have. Some people don't even know that they have dividends lying somewhere unclaimed. So it's just to widen the spectrum of communication to the public. That these dividends are unclaimed. But again, I understand that for, like you said, in your own company, and there are companies that are even bigger when it talks about shareholders. Than your own company. You may have to take 2 editions of the newspaper to do that. Again, we'll see how many of these things and how much of them we can address by regulation.
Thank you. I have a question for Tosin. Tosin, Section 427 of CAMA restricts the profits of a company available for payment of dividends only to the company's accumulated realized profits, less the company's accumulated realized losses, so far as they've not been either previously utilized or previously written off. What are the key implications of these provisions, do you think, on dividend payments?
Okay. I think it just makes a lot of common sense that we have such a provision in the Companies and Allied Matters Act. I mean, a lot of us that work in the corporate sector know the kinds of sharp practices that happen in corporations, that just for the benefit of keeping the shareholders happy, companies are paying dividends from, sources that are untowards. We have heard, historically of companies that take a loan to pay, dividends. I think this makes common sense that you are paying out of non-distributed and non-capitalized profits, and that if you have a loss, you will first of all apply your profits to deal with, to block the holes that you have in the company. I think it just makes common sense, So for me, you should kill what you eat. A lot of times in a lot of companies, especially the companies that don't have, very savvy shareholders, management is killing the company and they are paying dividends and nobody is paying attention to the actual financial health of the company, right? So, I mean, for me, this is good. I don't see anything wrong with it. I don't know. I mean, I think that this is just trying to enhance, governance practices across corporations, especially the ones that are not sector regulated, or the ones that are, private companies or smaller, enterprises where they may not have, a savvy board or independents that are checking the excesses or the activities of management, or sometimes even the board. I think it makes a lot of practical sense, and I'm happy that we have that provision in the new CAMA 2020.
Okay, so I want to speak to also your M&A expertise. Some of the provisions in the new act include the introduction of a statutory right of first offer. That's under Section 22B. And that prohibits a member of a private company from selling its shares in a company to a non-member without first offering the shares to existing members, right?
Yeah.
Other provisions also relate to the required approval of all shareholders for the sale of assets having a value of more than 50% of the total assets of the company, which may be a difficulty again in a widely dispersed shareholding structure. To what extent will these provisions provide additional protection, in your view, for remaining shareholders? And does this mean, how does it affect the drag along, tag along rights? Does it mean that this will not be recognized by under CAMA? And what are the benefits do you think it provides, and what practical challenges do you think these provisions may pose, if at all any?
Okay, I'll start from the ROFO, which is the right of first offer. I think that already there was a similar provision in the previous 2004 CAMA that talked about the restriction of transfer of shares, from a shareholder in a private company. But I think that what the new act has done now is to give it its proper name, which is a right of first offer to your existing shareholders. So typically in a private company, a lot of people don't want to have, to be, for the want of a better word, to be unequally yoked with a shareholder that they don't want to be in bed with. So just for you to have that cohesion within the company, it's necessary to say, look, if you want to exit, which you have the right to, do not force an external shareholder on us who are in the company. Let us have the right to buy you out so that we can, keep that internal cohesion if it's a private company. So I think that was there before, and I think it's good in terms of sale of assets, and making it a requirement for unanimity. I think that it is good. It is good in terms of governance practice. I think it's also good for minority protection. I think that the threshold is fair. I mean, if you're going to dispose of 50% of the assets worth 50% of the net value of a company, it only makes sense that even the minority have a say in the way that decision is made. So I think that it could be you can view it as being unnecessarily unfair to a majority shareholder who ideally, by the virtue of having majority interest, should have at least some more influence in decision taking. But all in all, let me also talk about the somewhat tag along provision that is now entrenched in the new CAMA. So if you want to sell, up to 50% of the shares in a company, if you want to buy into a company and you're taking a majority stake, basically, then the other shareholders can decide that, make us an offer and let us tag with the shareholder that is going. Now, my view on this is the CAC does not want the lawyers to make money from M&As again, because they have drafted in statutorily, those provisions that, you would typically, want to put into, corporate and constitutive agreements when you are, advising, companies. But I mean, I think it's good. I think it's good for the market. It will be good. I mean, it will open the eyes of a lot of, minority shareholders and not so savvy, investors and shareholders in smaller and mid-sized companies to know that, some of these sophisticated provisions and protections that actually exist when you're doing an M&A, that they can actually benefit from it. So, I mean, I think it's good. People that have majority stake in companies may not agree with me, but I think it is for the greater good of the market. I absolutely am happy about it.
Okay. I'm sure more questions on this may come up during the Q&A time. And I really do want to give participants an opportunity to ask questions and to have their views taken as well. Mr. Osho, the Section 18, I mean, and it's not just Section 18. We've heard from Mr. Shonaike regarding the philosophy of the Act being to make things easier for small companies. So Section 18.2 of CAMA 2020 introduced single individuals' right to form a company, and small companies, as redefined, are also permitted to have one director. We had a discussion during the dry run yesterday as to whether the threshold for a small company was not too high and should actually be much less, but the jury's out on that. Now, you're familiar with the MSME sector, and obviously you've lent into MSMEs and SMEs. Do you think that financial institutions would be comfortable granting access to credit to single individual formed companies? And do you think that there's a possibility that good governance may be eroded with only one shareholder or director, no company secretary, and that shareholder, that one shareholder and sole shareholder and sole director basically run the risk of operating they run the company as they wish? Do you think this would raise any corporate governance concerns from the perspective of a lender?
Okay, thank you, Ms. Jagun. Let me just say, with respect to lending to single member companies and potentially MSMEs, there are institutions that have been waiting for this amendment to the CAMA. Institutions that were set up specifically to bank these people and provide loans and access to finance to such institutions. One of such institutions is the Development Bank of Nigeria, a clear mandate to make loans available to MSMEs, to improve MSMEs' access to finance, make MSMEs more formidable. So yes, you have specific institutions that have been waiting for this. In terms of larger commercial banks and whether banks will lend to MSMEs, I'll just say this. There are a lot of considerations when banks make credit decisions. And one of such is, a couple of these are the business reputation of the lender, viability of the underlying transaction in terms of repayment, collateral coverage, which is statutory, realizability of the collateral. All this, I mean, outpace and outmatch the issues as to whether it is a single member company or not. In the credit appraisal process, relying on this criteria, banks would typically lend to MSMEs if they are comfortable with this. And let's remember that single member companies are also legal entities. It's an incorporated entity, it has a separate legal personality from its owner. It's not different from the multiple shareholder companies. So yes, banks will lend to MSMEs. And I believe a lot of MSMEs will take advantage of Section 18.2 of the new CAMA to get registered. With respect to whether there will be an erosion of corporate governance and corporate governance practices arising from single member companies, well, we don't have any empirical data upon which we can make that judgment or come to that conclusion. But I tell you this, we've always had multiple shareholder companies, and we're still grappling with corporate governance.
And more so that, so if we already have multiple shareholder, multiple director companies, and we're grappling with corporate governance, more so, and the argument is more so when you have single director, single member, and no company secretary to kind of guide such an organization at its inception, at its foundational stage. Which again brings me to the question of, okay, really should, is it the view of the CAC that company secretaries really don't have much value to give to small companies? Or otherwise, why is the requirement, why can company secretaries and auditors be dispensed with so easily?
Okay, let me start from the corporate governance angle as to whether single member companies will erode corporate governance practices and all that. I'll just say this: corporate governance is about transparency, it's about ethics, it is about compliance, it's about social responsibility and social investment. And more importantly, it is about commitment. Corporate governance is a journey. And so it doesn't matter. Yeah, you can say the single member companies will not have the benefit of committee structure, board structure, the separation between owner, chairman, and MD CEO. It's one person. But I tell you this, it's all about commitment. We have very fine examples in Nigeria of companies that started as a one-man's business, and they've grown to international conglomerates. So it's a function of commitment. And I think as long as these single member companies are owned by people who are committed and open and see the benefit of good corporate governance, I'm sure we can achieve a lot of progress in that area. Mind you, it might be easier. It can be argued that it is easier for one man to push through the kind of initiatives that will enhance corporate governance than when you have an army of people and you have diverse stakeholders and you have diverse interests that you have to balance. You have board dynamics that you have to take into cognizance. Single member companies, you have one person, provided he has that commitment to drive through and pull through. Yes, why won't we have good corporate governance practices in single member companies? And another thing to note is that we already have the structure on ground to support these single member companies. We have NASME, the National Association of Small and Medium Scale Enterprises. We have SMIDAN. So we have the Development Bank of Nigeria. We have a whole lot of support for these people. And we're going to drive to make sure that they understand the benefits of good corporate governance.
Correct. Thank you very much.
If I may just add to what Mr. Osho has said, I think that clearly we cannot deny the fact that single member companies are going to dim the line of legal personality. Mm-hmm. We cannot deny that fact, because it will clearly happen, and you will find situations where you cannot actually separate the owner from the business in that sense. And the reality is, even though there are a lot of organizations that would lend to these entities, they would take them through the standard underwriting procedure as they would take an individual. It only makes sense, that's the way, it should be approached. It makes sense that that's the way, it should be approached. But that said, I think that it doesn't, I mean, that disadvantage doesn't take away the fact that it's good and it is progressive for us to have single shareholder companies. And the reason being that, you know, for strategic reasons, it may make sense to, you know, go in that direction. If I want to own my business 100% and I am ready and willing to finance that business without any, you know, support or interaction from anywhere, if I put my money in 100%, then I should have the right to take decisions 100%. Where I need support, I would employ people into management to provide the needed skills and support, you know, to run the business. So people should have, you know, that stake. Then talking about governance for, you know, these entities that are now going to be outside of, you know, the reality of maybe having a company secretary or not having a company secretary. I believe that one of the things that kills businesses fastest in sub-Saharan Africa is the burden of governance. I think so. There are so many companies that we have in Nigeria that look good, but they are dying because they took private equity money, and these private equity investors have made some bogus, you know, governance demands on them. They tell them to have 7 committees. They tell them to have, I mean, they balloon the management team and tell them you will have head CFO, you must have financial controller, you must have this, you must have that. The first thing that a business should be trying to do is to survive and make profits, to run its business. But many times you find yourself in a situation where somebody has, you know, made you sign one SPA where you have to have like 15 people on your management team. Your organogram is as big as, you know, the one for the World Bank. And, you know, and then you are busy dealing with governance and not doing business. And at the end of the day, you know, you just start having, a very big problem, you know, in the organization. So there must always be a balance between the primary objective of a business, which is to trade or do whatever their key objective is. And then, you know, governance should enhance business and not the other way around. So I think that, you know, that is the balance that we need to, you know, look out for in the way that, you know, we approach these things.
That's true, Tosin. If I can just say this, what CAMA has done with respect to private limited liability companies and company secretaries is that it has just made it's no longer mandatory. It doesn't say you shouldn't have. It has just taken away that mandatory aspect of it. So, and I want to assure you that a lot of companies will still have company secretaries because there's clear value in having one. There's clear value in that. So it's not because I work for a public company and I can see Ms. Jagun smiling because I don't know. I think Tosin's trying to take us out. She's out of the job.
No, they are going to go to DCSL, not me.
So it's no longer mandatory, but then there's still, I mean, clear value in having one. And you don't have to have an in-house secretary. You can have a firm.
Absolutely.
Looks after your secretarial service.
Absolutely. I think you need to have that balance and to put across that balance that there is much benefit to be obtained from making sure that these structures are in place, because when it comes time to taking your business to that next level in terms of getting finance, applying for grants, the structures you have in place clearly would help. So time is fast spent. We have not even been able to consider some of the things that we wanted to talk about regarding netting off. I'm hoping that we'll have time during the Q&A session to deal with those questions. But I really do want to take the questions of the participants on the call. We have quite a number of questions that have come in. 17 questions. I know some questions were posted on the chat group, but I really would encourage you, if you've posted a question on the chat and not on the Q&A, to please make sure it's on the Q&A now. So I'm going to take some of these questions. Obviously, there are questions that have been answered, and where they have been answered, like we've got a number of questions on independent directors. These have been answered. So I really would not be taking I really would not be taking those questions. We have an interesting question from Ayokunle Ayoko, and he says, my question is to Mr. Shonaike. How does business continuity play out on the death of the sole member and sole director of a single member company?
Thank you very much. Yes, we've had these questions over and over again. I mean, there's a lot of interest on whether a company can continue after in a single member company after the death of that member. But what I also say is that, like Mr. Osho said, the company is different from the promoter. It's different from the yes, exactly from the shareholder. So whether the demand dies or not, the company still exists. The only way to kill a company is to liquidate it. You know, and okay, we have another option under the new law now for striking up at the instance of the company, but there are also conditions to be fulfilled before that can happen. So I tell people it's just the same way the shares in the company are personal properties of the shareholders. So these shares pass on to whoever succeeds that person. The law clearly states what happens when a shareholder dies. There are even under the current the 1990 Act, such situation was contemplated when it says that when all shareholders and directors die. You know, so it's now left for those who succeed them, who are entitled to those shares, to elect what to do, whether they still want to continue the business or they want to kill the business. So there really is no problem with succession, perpetuity. No. There's no problem with that.
Okay. We've got questions regarding when is the commencement date of the new CAMA. Very quickly, because we have quite a number of questions, can you perhaps just give us an answer to that?
Okay. Like I said in my earlier submissions, that there is no date indicated on the bill. I mean, on the act as we know. But once it is gazetted, it will come into, it's already a law. We'll start to implement it. Now, when it will be gazetted is what we do not know. But we're working to see that worst case by 1st of October we can start running with it. And I told you earlier that the EBC is even looking at an earlier date.
Okay, yeah. We mentioned that beforehand, that even though there was a webinar just before this one, and 1st of October was touted as a possible date, but we understand that the Registrar of Companies is looking for an earlier date. Brings me to the next question. It says, I have the feeling that majority of the existing corporate MEMAs, both private and public, are likely to be inconsistent with some provisions of the new CAMA. What happens in this instance? And specifically, this doesn't clearly give companies much time to make the amendments before implementation dates. And I mean, this question is for all the panelists, really. What do you think companies right now, businesses should be prioritizing right now?
So if I can just go first, I'll say, I'll put it this way. So what companies should be looking at now is taking a very, very careful look at the MEMAs, carrying out gap analysis to see where there are gaps in their own operations and structures and what the new CAMA requires. And I think by now, in-house counsel should be engaging management and likely the board on the aspects of the CAMA that they need to comply with. We're going to see a lot of restructuring, a lot of activity going into the year. And the earlier we all do our best to comply with the new provisions, the better. The time is really short, and I don't expect the CAC to start penalizing non-compliance, because really that wouldn't be fair. We all know that making corporate changes requires a lot, and we really need to be given time to comply with these provisions.
Okay. Sorry, yes, please, Mr. Shonaike.
Yes, just like Mr. Osho said, the challenge now is on companies to start looking, understanding the law, and then determining where they need to make amends with the articles and operations. But again, usually, as is the practice in drafting, you would allow a transition period. So most of those provisions that are inconsistent with what was will always allow a transition period. So it's not something that you just start, once you start running with, you start penalizing operators. No, it's not going to be like that.
I'll take your word for that, sir.
We have a question. Sorry, sorry, Tosin, please go ahead.
Well, not much to say. I mean, I just wanted to obey your instruction that we should all speak. But I think that there are mandatory provisions in the CAMA and there are non-mandatory provisions in the CAMA. So the ones, there are a lot of provisions that actually make room for companies to determine, what rules will govern them. And it says that, except where otherwise, approved in the articles of the company. So there will be provisions where people can still opt out of some of the non-mandatory, provisions in CAMA. So I know that it's actually, quite a read. So I would say that people need to just don't hastily go and do anything. I want to believe that at the very minimum, the Corporate Affairs Commission will have to give. We need to understand the breadth of, of the new legislation, and then the terms of, corporate changes will be required within our different organizations. So I would say, don't be in a hurry to go and start, making changes to your constitutive documents. First of all, understand what is mandatory, and that's where to start from. For the ones that are not mandatory, you still have, the right and the power to determine, how you want to run your own affairs, and in that wise, you have the latitude to play it, in whatever direction works for your critical stakeholders. Okay.
And I think more than that, before you actually make any changes, wait to see the gazetted copy of the act.
Very true.
Yes, exactly. A lot of concern around that. So yeah, we'll wait for that.
Okay. But certainly the gap analysis is very, very important. We have a question, and I think this is possibly the last question we can take because of time. And before we get final words from the panelists and moderators, and I'll try and incorporate some of the other questions into the final words. Let me see if I can. I think some of these questions, I would like to encourage the panelists to please go into the Q&A box and respond to some of these questions. Some of them can easily be taken. But there's a question here on, somebody wants to understand what is netting off. And that was something that, or netting, that was something that Mrs. Ajose was supposed to have spoken to. I actually had a question for her on this. This is covered by section 718 to 721 of CAMA, and it introduces the concept of netting and the use of netting to help assess and reduce financial obligations. Although, we had insolvency set of provisions under the old CAMA, by the provisions of CAMA 2020, netting arrangements can now be contracted for and enforced against an insolvent party or a guarantor or anybody providing security. So, Mrs. Ajose, can you help provide an overview of the key provisions and what you believe are the anticipated implications and benefits as they relate to the financial sector and capital market sector?
Okay, so this is one of the things that we've been pushing for several years. For those of us that practice in the capital markets, we know that this is one of the things that has precluded the growth of the Nigerian financial markets. The fact that we did not have netting and set-off laws in Nigeria. And basically, the reason why this is very important is because netting is at the core of securities trading, currency trading, derivatives trading, and sometimes, invoice trading. And I'll explain basically what this means. So the concept of netting is Tosin owes Mr. Osho 10 naira. Mr. Osho owes Tosin 20 naira. Tosin should never have to pay Mr. Osho anything because Mr. Osho owes her 20 naira. Rather, Mr. Osho should, based on the obligation between the two parties, simply pay Tosin 10 naira. So the principle of netting is if you owe me and I owe you, we net the differences between, our obligations to each other. And whatever the balance is, the party who owes that obligation then needs to settle it, right? So what has happened previously is that unlike what we have in other jurisdictions where parties can actually enter into an arrangement to say, we have this netting agreement between us. I will never have to pay you what I owe you if you owe me without first deducting, what you owe me. So you can't come at me and enforce your right over what I owe you if you are, indebted to me in any way. So that is the principle. That is the principle of netting. So in the capital market, what typically happens is when you're doing derivatives trade, which is where, you have contracts that are to be performed on a future date, right? Circumstances in the different parties can change at any time. A party can go into insolvency or any other kinds of, circumstance that makes it impossible for them to perform, that financial obligation that they have to you. Now, what happens is if you do not have netting laws that protect, these parties in the event of an insolvency situation, what can happen? So let's give an example. Let's say Deal HQ has entered into some arrangement with another party, right? And if Deal HQ goes insolvent, Deal HQ is owing, one party 10 million naira, right? If the other party is owing Deal HQ 100 million, right? If a liquidator is appointed over the affairs of Deal HQ, irrespective of our own position, our own internal financial position, they can actually, take action against the other party to enforce the rights without anybody giving, any consideration to what is being owed to the other party. So basically what this law is saying is that if parties enter into any netting arrangement where, you have my money, I have your money, I should not have to pay you, you shouldn't have to pay me, we can just net it off each other, and then whoever owes the other party a balance then gets, to pay that that to the other party. And if there is a netting arrangement, it is insolvency remote. And what that means is that, even if the other party is unable to, pay, once we've had that obligation and I have anything to the credit of the insolvent party, you can't come after me unless you have set off our liability to each other against themselves. If there's anything left, then that's what I have to pay. So it's somewhat close to the principle of, what a lien is. If I have something in your custody and you owe me, I don't have to release what I have in my custody until you have performed, in full what your obligations are to me. So for the capital market, you have situations where, to be able to, ensure that the market, doesn't get to, that we have a market that is where there can be certainty of obligations. We have to make sure that, all parties can, trust that when there is to be performance of their obligations, irrespective of the solvency status of the parties that they have dealt with, that these netting provisions will protect them from being able to give off what they owe to that party if the party also has obligations to them that has not been performed. And then we have, for derivatives transactions, we have central clearing houses that ensure that, there's a multilateral netting of obligations, across, all the parties within the financial framework. And then basically what that does is it ensures that, the market has stability and that you can actually project that, when there are obligations, there is assurance that those obligations will be performed when they fall due in the future. I've done my best to explain it as granularly as I can. I hope that I didn't do too badly.
That was great.
I hope I didn't do too badly. So,
thank you. There are further questions, but I think what we would do, and what I would like us to do, is to hear from the speakers again. What are those areas that you think CAC needs to now go away and look at, and with a view to possibly providing either more guidance or amending? For example, we have a question here from Lekman Augustine, where he has said, you know, FIRS has defined a small company as a company with, I think, a turnover of 25 million, whilst with CAMA, it's 120 million turnover. This whole issue about the shareholding qualification for independent non-executive directors is another area. The issue of perhaps public companies and virtual AGMs, because currently public company, the virtual AGMs don't extend to public companies. So what are those areas that you feel, and these are just suggestions, you may not agree with me, what are those areas that you feel need to have another relook? We'll start with Ms. Social.
Okay, thank you, Ms. Jagun. So I like the Corporate Affairs Commission to take a very, very careful look at this issue of public companies and the issue of virtual AGMs by saying that by limiting the ability to hold virtual AGMs to private companies, is the CAC saying that public companies did not suffer from COVID or were not affected from COVID? My humble submission is that we were even more affected by this because we have so many shareholders, and moving them around the country is a serious concern. We're in this together. CAC really needs to look at this and come out with a guidance. I would have expected that the CAC would have reserved some powers in this regard in the CAMA. So a provision that says a public company subject to the approval of the commission may hold the virtual AGM would have solved this problem. And then the CAC would have come out with guidance and we will comply. So I think this is one area we really need to look at. Secondly, the issue of independent directors and the definition of independent directors, we really need to be careful about this. We really need to be careful because the CAMA is an act. It is an act of the National Assembly. From when it was signed, okay, let's just say from when it is gazetted and we start running it, if I'm nominated, I have 25% of the company and I'm nominated as a shareholder. You cannot disqualify me on the basis of the national code, which says 0.01%, or the SEC code, which says 0.1% shareholding. You can't. So it's a real problem. And we really quickly have to do something about this. I think that's the takeaway I'd like the Corporate Affairs Commission to go well.
Correct, thank you. I'm going to take a few other questions on the Q&A, but I would like to hear, so for those who are still posting questions, please post them. Before I get your view, Tosin, and we go over to Mr. Shonaike for a response. There's a question here which I think is very important by Yomi Odifren. He says, please confirm whether for the purposes of Section 705 of CAMA, requalification of an insolvency practitioner, the Nigerian Bar Association comes within comes within the contemplation, and I suppose by extension I can, of any other professional body recognized by the Commission. That question is for Mr. Shonaike. You're mute, sir.
just before Mr. Shonaike answers that question, I'd just like to say it's like lawyers are really out for the Corporate Affairs Commission with this act.
Not at all. We love
because
that.
Yeah, because we don't sign any declaration of compliance anymore. So lawyers are. So go ahead, Mr. Shonaike. It would be good to hear your view on this.
One of the contemplated other professional bodies recognized by the Commission.
Yes. It's actually an interest for the NBA. Drawing from the earlier session that was organized by the SBL, Section of Business Law. Yes, NBA comes within the purview of any other body, professional body recognized by the Commission. In fact, it was advocated that because what another thing that required is for those professional bodies to include in their instrument, whether it's by charter or by constitution, that they can practice as insolvency practitioners. So the RG did advise NBA to go back and look at its constitution and insert that clause, and it will be okay. Like you said, it also extends to ICANN.
Correct.
Or ANAN, as it were.
Or ANAN.
As it were. Right.
Correct. That's very helpful. I'm sure lots of lawyers can go to bed tonight knowing that that part of their bread and butter is intact. Thank you very much. Tosin, your views on what are the areas that you feel that CAC needs to kind of like look at again and maybe provide either further clarification or amendment?
To be quite honest, I haven't read the whole of the act to the point where I can, articulate all the things that I think need to, would require a second look at, or maybe reconsideration or amendment. But what I would say is that I find a lot of the provisions to be overly prescriptive. I think that CAC needs to, the Corporate Affairs Commission as the core MDA that is responsible for actually operationalizing this act, needs to take a look at that. But I think primarily what I would say is that they should give themselves some time to actually see how things pan out. I mean, sometimes until you practically start trying to implement a law before you would understand, very clearly the impracticality of some of the provisions or the shortfalls. I mean, we've talked about the ones that easily come to mind, and we've analyzed them on a lot of this fora, but there will still be some that would come up just in the course of trying to operationalize them, where you would find that look, this thing doesn't work, cannot work, is impractical, is unreasonable, or maybe just need to give a bit more room, or you need to give better understanding. I would say right now the CAC should focus on just preparing themselves in terms of manpower and capacity to be able to implement the CAMA. They have arrogated to themselves a lot more responsibility than they had before, so they would have a lot more work to do on a day-to-day, so they need to be prepared for that. I also think that they should focus on ensuring that whatever issues can be fixed by through their guidelines or regulations, that that at least that can provide an immediate succor to the market, and then the areas where clearly are go to the roots. Those kinds of changes, they should quickly, have, enough gathering of other stakeholders to start looking at how quickly the amendments can be done, because this law is too central to the corporate existence of Nigeria to, leave things to fester. So I think that, just being a bit more, proactive, in those areas is what I would suggest, rather than indicating the specific provisions that possibly need to. And if we find anything, maybe you will share Mr. Shonaike's email, and then we can send to the CAC our opinion on some of them and the areas where they need to look at. I don't know whether DCSL would maybe help to just aggregate some of those, but right now I don't have any specific ones that I can say because I haven't read, in detail the whole CAMA 2020.
Thank you, Tosin. And Mr. Shonaike, before you respond, again, and give some indication of, for instance, whether you're still taking comments and submissions from interested parties on suggested or proposed guidance that's required, changes that are required. There's a question here before you give your final comments on, please can you throw more light on this? This is from an anonymous attendee. It says a company or its holding company is not allowed to enter into an arrangement with its directors or controlling members, so individuals or joint holders of 50% voting power, in respect of non-cash asset property transactions of a value as may be prescribed by the Commission. Will the CAC prescribe the value at every given time, or is there going to be a guideline to that effect? Are there thresholds? Are there guidelines? I mean, what is the position of the CAC on that? And then also, how can we engage the CAC in terms of, taking this discourse for, further and getting clarity? What's the process? Thank you. Mr. Shonaike, you're on mute, and perhaps you're hanging. Hello? Oh dear. I think we don't have him on the call. Nikki, I don't know if you can get hold of him in the meantime. If we are not able to get hold of him, I guess we would have to maybe take this offline, and I'm sure DCSL will ensure that all the questions that have been asked are answered, and that there will be maybe every attendee that attended, every participant on the call will be sent a list of questions and their responses to all the questions. We seem to have lost Mr. Shonaike. With that, I would love to just thank everyone, all the speakers, and hand over, and also the participants for, making this session very vibrant and asking quite a lot of questions, which I hope we've been able to attend to. We've got some comments here, which I will just quickly touch on. It would be good if the CAC could stay very open-minded as this new law becomes operational and approach it with a growth mindset. That has come from one of the participants. Unfortunately, I don't have the full name. I've been told that Mr. Shonaike lost connection and is trying to sign again. Mr. Shonaike, are you back with us? If you can, please let me know once you're back with us. Well, obviously you. Okay. There's another comment here this is from Adiola Egbeyemi. She says, regarding Mr. Ayoku's question, I'm concerned that Mr. Shonaike's response is incomplete. The key man risk is high, and modern corporate governance sees the public as an important stakeholder. I think we need to be clear on succession in order to ensure business continuity. So welcome back, Mr. Shonaike. I was going to give you an opportunity.
Thank you very much.
And tell us, what's the process? How can we engage the CAC regarding some of the concerns that we have as practitioners, as companies? Open, we have a comment here saying, it would be good if the CAC could stay very open-minded as this new law becomes operational with mindset. It's also very important, on the other hand, to ensure that there is implementation and follow-up, and that things are not left to, there's enforcement, you know, so that the acts can be taken seriously, and the gains of the acts can be consolidated upon. But I'm just going to allow you to, you know, having heard all that has been said, to perhaps talk to us about your focus areas, and how we can engage you. Thank you.
Thank you very much. What I would say is that if for engagement, I think this is, if there's any time to engage, you say it is now, because we're looking to set up, we've set up an internal committee on regulations, but we're looking beyond that to set up a wider committee that will involve stakeholders, the public, just like we did for the CAMA before it became law. So if there's any time to engage, it is now. I know there will be, we'll put out a notice very shortly between now and next week on how you can submit your memos or your submissions or anything, you know, that you want addressed, you know, the gaps in the law and what we may address by regulation. And again, it's the RG operates a very open door. It's very easy to access it anytime. So if it's something you want to come and sit in and discuss with him, find that's okay with me. I mean, if you're around, once you come, we can always see him at any time if he's around. That's not, accessing him is not an issue. That's not an issue. So it's easy to engage the CAC, you know, and you can always drop things by mail to us. We'll always look at it. We'll always look at it. The area of, for us, some areas may not come into effect immediately because we'll need to put in structures to accommodate them, more so that everybody's looking at this thing should start immediately. So we're still going to give some time, you know, for people to comply, and then before we even start talking about enforcement. But once we start enforcing, we hope to enforce, and we hope to also monitor progress. In fact, the RG did say that from tomorrow, we'll start publishing how we're doing now to compare with how we'll be doing after we start implementing the law. We want to see how we fare, whether there's progress, and to know, also determine where the issues are so that we can plug those gaps. Now, something I also like to quickly just clarify to mention, you know, so that it doesn't seem like we were not taking some of these things on board when we're looking at this thing, is this issue of e-meetings for public companies. It's unfortunate that COVID happened. I mean, nobody could have stopped that. Nobody could have also envisaged that it would happen when it did. We didn't know that it was coming to ground everything like that. But what we need to also understand is that this law, this document was ready as far back as 2 years. So it was not something that just happened. It was passed by the 8th Assembly and transmitted to Mr. President. For some reasons, he did not sign it because there were 1 or 2 things he wanted addressed. Now, those things, he came back, he did, and he came back. Those things were addressed and quickly passed, I mean, went through the 9th Assembly. If we knew at that point that there were a lot of things that we needed to address. But if we had attempted to do that, this law would not be law today. We would have had to, because that would now be introducing a whole lot of other things. And the 9th Assembly will tell you, no, we're going to look at this thoroughly, just like the 8th Assembly did. And with the 8th Assembly, it took so long. The first draft of this act was submitted to the National Assembly sometime in 2014-15. Real work started on in 2016 thereabout. So, I mean, you can look at that journey. So it was, for us, it was like, let us start this. We've seen these gaps and we'll see more when operators is exposed and they see it. Let's note them for a quick action on amendment. Thank you.
Can you, sorry, thank you very much, Mr. Shonaike. Can you answer the question that was asked regarding the prohibition on companies entering into arrangements with directors or controlling members in respect of non-cash asset property transactions of a value as may be prescribed by the Commission, and whether this is there's going to be a guideline or it's going to be something that is addressed on a case-by-case basis by the CAC?
No. For anything that requires the prescription of the Commission, there will be guidelines.
Okay.
There will be guidelines, and those are part of things I said we'll be working on.
Correct. Thank you very much. I've tried to keep the questions and discussions to that which is applicable to businesses and not touch on incorporated trustees on this call. But Mr. Shonaike, I will be getting in touch with you because I think we need to have a webinar specifically addressing the situation with incorporated trustees, particularly because there is a lot of there's a lot of controversy regarding some of the provisions, quite a lot of them not justified. So I think it would be good to kind of like have some clarity on that, and I'll get in touch with you regarding that. That saying, I just want to thank everyone for what I believe has been a very vibrant discussion webinar, and I hope a lot of questions have been answered. I'll hand over now to Chinedu, I think, to take us forward. Thank you.
Thank you.
We can't hear you, Chinedu.
Yeah, thank you very much, ma'am. Thank you very much, ma'am. Wow, wow, wow. What an insightful session. Many thanks to our moderator, Ms. Untitled Chapter, for being such a reliable anchor and for ensuring that today's proceedings was as seamless as possible. Thank you very much, ma'am. We also want to thank our erudite panelists, Mr. Tolulope Chonaike, Ms. Tosi Ajose, and Mr. Ochokola Ocho, for sharing your learned insights on the new acts and for clearly dissecting the legislation and its impact on businesses in Nigeria. We are indeed grateful and we look forward to having you again in our future webinars and training programs. So the discussion will now move to our respective offices, homes, social gatherings, and of course, the social media. Our stakeholders will continue to engage the regulators of fine-tuning the act and resolving gray areas and matters that are not in the interest of businesses in Nigeria. But before we leave, we would like to use this opportunity to invite everyone to our upcoming training programs, particularly training on business continuity and crisis management, scheduled for Friday, 28 August 2020. So alongside providing valuable insights on business continuity, the session would also focus on information technology governance, compliance management systems, and reporting requirements under the Nigerian Code of Corporate Governance 2018. So many thanks once more to our panelists and to our audience for honoring our invite. We look forward to welcoming you to our future webinars and training programs. Good evening, everyone, and please continue.
Thank you, Chinedu. It was really good being here, and I hope to see you on other
Thank you.
Have a nice evening.
Thank you, Chokola. Thank you, ma'am.
Well done, Ms. Jagun. Very excellent moderation. Thank you very much. Well done. Have a nice evening, Mr. Shonaike.
Thank you, Mr. Like, continue to see us, sir.
Yes.
Yeah.
Okay, then bye-bye, everybody.
Bye.
Thank you.